Good afternoon, and thanks for joining Washington, D.C.-based Jennifer Schaus & Associates in our Get FAR Cited in 2020 complimentary webinar series. As you know, the FAR, or Federal Acquisition Regulations, is the rulebook that the federal government must follow when making purchases. Our webinar pulls from contracting experts to explain each part of the FAR. It's complimentary and recorded. We will post all of the recordings on our website and YouTube channel, where we have over 400 government contracting webinars available for download. A special thanks to our webinar partner in this series, the National Veterans Small Business Coalition Education Foundation. Please visit their website to learn more about the organization. We would also like to thank our friends at Open the FAR for their sponsorship. If your organization is interested in sponsoring the series or one part, please contact hello@jenniferschaus.com. And now a little bit about us. We work with primarily large businesses to help them navigate the federal marketplace. We work with both product and service companies as well as software firms. Our clients span the globe and include publicly traded organizations in a variety of sectors. We provide market analysis reports, contract administration, contract vehicle assistance, and more. All of our services can also be built into a training course for your team. Learn more about us at our website. And now we would like to let you know about some ways to reach government and government contractors through us. We offer advertising and sponsorship opportunities through our weekly newsletter and also in our webinar series. For pricing or to place an order, please email us at hello@jenniferschaus.com. And as noted, we have over 400 government webinars in our archives. As we continue to educate federal contractors, I would like to bring to your attention our webinar schedule for 2021. The full schedule and speakers are all confirmed. First up is a monthly series called the GovCon Live Q&A Cafe. This is a live webinar series held each month. These will take place on the second Friday of each month in 2021 at 12 p.m. Eastern. We have assembled a group of 4 panelists who are subject matter experts on a specific federal contracting topic. The panelists will make a short presentation about the topics listed here on your screen and then take your live questions about that topic. So for example, January will kick off with our panelists covering CMMC on Friday, January 8th. Our panelists include attorneys, consultants, and other industry professionals. You can sign up on our website under the Q&A Cafe tab. Sponsorships are available, and please email hello@jenniferschaus.com for a media kit and pricing details. And our second webinar series in 2021, we will be covering each part of the DFARS, or Defense Federal Acquisition Regulations. Similar to our current FAR series, this will be a weekly series dedicated to defense contracting, its rules and regulations. This series is complimentary and will be held on Wednesdays at 12 p.m. Eastern. We will run through the parts sequentially, meaning that we will start with the year with DFARS Part 201 and finish with Part 252 at the end of the year. You can sign up on our website under the DFAR tab. And again, sponsorships are available. Please email hello@jenniferschaus.com for immediate kit and pricing details. And let's move on to learn about today's speaker, Andrew Victor. You can find his contact information here. And today we're covering Part 49 with Andrew. Thank you so much for joining us, and the floor is now yours.
Oh, great. Thank you. Hello, everyone. My name is Andrew Victor. I'm an associate at Nichols Lew. Nichols Lew is a small law firm based in Washington, D.C., and it's a government contracts boutique. It's only about 10 or 11 attorneys. So everything we do is with a government contract or adjacent to a government contract. And today I'm going to talk about FAR Part 49, termination of contracts or terminations. This presentation assumes some familiarity with the FAR. This isn't a government contracts 101 kind of class, but also this isn't a in-depth review of all aspects of a termination. It can get kind of detailed. So this is more of a 201 kind of class. And I should speak for about 40 minutes. And as for the topics, could you go to the next slide, please? So the next topic, I'll be covering all the overview of Part 49. Well, as you can see, Part 49 has 6 subparts to it, and this applies to terminations for convenience, T for C's, and terminations for default, T for D's. Part 49 does not apply to terminations of commercial item contracts under FAR Part 12. So if you're a contractor providing something that can be easily bought in the marketplace, in the contract is under the -12 clause, you're 52.212 clause, it's not going to be governed by FAR Part 49. The principles of FAR Part 49, however, can be used as guidance in terminations for commercial items to the extent that they're consistent with FAR Part 12. And also, the contracting officers can look to FAR Part 49 when determining equitable adjustments for any kind of contract, except for cost reimbursement contracts. So Part 49 is pretty broad and useful. And as you can see, I don't need to read every subpart, but there's general principles which we'll cover at length, and then dive into fixed terminations for convenience. T4C is a fixed price contracts, which are pretty common, and then touch upon cost reimbursement contracts, and then get into the T4Ds. That's sometimes pretty fraught for a contractor, and then we'll just briefly go over contracts, clauses, and formats, time permitting. That all this, the clauses and formats, that those are less informative, but important to the actual contract documents. So can we go to the next slide, please? And so for dealing with general principles under subpart 49.1, I wanted to have a couple slides on these here. Generally when there's a termination that's going to happen, you're going to get a notice. A contractor is supposed to get a notice of termination from the CO. This will be in writing. It's going to, it can be somewhat informal. It could be an email from the CO to the contractor. It doesn't have to be in certified mail. And the notice of termination should contain all the basic information to identify what's happening. What is the contract being terminated? What's the contract number? When is it being terminated? What's the effective date? The extent of the termination. Termination does not have to be a complete termination of the contract. It can be partial. Maybe a couple CLINs get chopped off, or it can be complete and the entire contract has to be wound down. The notice should also provide instructions. Good COs will provide what steps the contractor should take in winding down performance, whether that is, dealing with inventory issues. Contractor will probably have to reallocate employees. Maybe there's essential personnel that are, required to continue performance on a partial termination. So this should all be contained in the notice of termination. And then, because terminations deal or address with a contractor's costs, there has to be some way to pay, have the contractor get paid, even though the work is stopping. So the FAR sets out in the subpart the principles for settlement. It talks about a negotiated settlement between the parties. The less favored approach is a determination by the contracting officer, just kind of straight up on the facts. You can also use vouchers. If this is a cost reimbursement voucher, a contract that's being terminated, these costing out vouchers, which is the standard form, or any combination of these methods. The key, though, is that the settlement should be fair. The FAR says that, and it should be prompt. It should not take a long time. Unfortunately, that's not always the case. And as I mentioned before, there is a preference for a negotiated agreement over a CO's determination. The FAR contemplates that the parties should come together at the table and get this done. So then also the FAR outlines, these reciprocal almost responsibilities between the prime contractor and the duties of the terminating contracting officer, the TCO, as the FAR references it. But for today, I'll just call it the CO, because usually it's the same person. So for the duties of the prime, upon getting a notice of termination, they should stop work according, to the instructions, and also pivot, and depending on the contract, terminate subcontractors that are performing on. So this flows down from the government to the prime, to the subs, and any lower tier subs. And another thing that prime should do is keep communication open with the CO regarding anything precluding the stoppage of work. Maybe there's construction that just can't be stopped immediately, or there's some sort of service being provided that can't be turned off automatically. So even though the contractor has the notice, to stop performance, they might have to continue for a little while, like a day. And also, if it's a partial termination, the contractor has the obligation to continue the non-terminated work. Sometimes that might take some sorting out. And then, because of the termination of subcontractors, the prime has the duty to come back to the CO if there's any legal proceedings or lawsuits initiated by subs against the prime. And hopefully the prime can settle with its terminated subcontractors. So all that framework kind of establishes ongoing communication between the prime and the CO. And ultimately what this leads up to is the submission of a termination settlement proposal from the prime to the contracting officer, and also addressing any needs for disposing of inventory. And so that the framework establishes a method for the contractor to get paid and also to stop the work. For the CO, after sending out the notice of termination, the FAR requires the CO to act promptly upon the termination settlement proposal. And there's a kind of a policy preference for finality. Okay, if the work, if the government has decided that's going to terminate the work, well, that's fine. But then, let's resolve all the outstanding liabilities. And probably, well, I would say in my experience, what often happens after the termination happens, there is a conversation that occurs between the CO and the contractor to address and affect the settlement. And basically, this can address all things relating to wrapping up the work and clarifying the extent of the termination and status of any other work, and maybe even identifying the subcontractors. The government does not always know. Can we have the next slide, please? And then further general principles that involve involve terminations. There is a specific part of the FAR that describes settlements with subcontractors, and it's well known, it's well established. Subs have no direct rights against the government. They can't negotiate. A subcontractor can't go around the prime and negotiate directly with the government. The prime can sponsor the sub, and the prime can, maybe act as an intermediary with the government. But oftentimes, at least in my experience, when there's been a sub involved, even if the sub during performance has had direct lines of communication with the government in a termination kind of setting, lawyers get involved, and there might be atmospheric change, and the formalities of contract will govern, and so maybe subs are going to be stuck with having to go through their prime. And then the FAR also contemplates, that the prime would have to settle potentially with its subcontractors. And in practice, this isn't always an issue because the prime will have flowed down all the appropriate contract clauses to the subcontractor. So the interactions that happen between the government and the prime should be mirrored with the subcontractor and the prime. And depending on the contract, there could be detailed instructions and approvals required for settling of subcontracts. And also, the government, in some cases, may assist the prime in settling with subcontractors. The FAR actually has a provision that says that in an unusual case, the government could come to the aid of a prime in effecting a settlement. Regarding settlement agreements, this is essentially another contract, right, to affect the end of the government contract. The FAR instructs that the settlement shall cover any set-off that the government might have against the contractor, and this is to be applied to the terminated contract. So it is kind of trying to resolve all outstanding liabilities. But the FAR also provides a lot of flexibility to the parties in crafting their settlement agreement. You could have a joint settlement that spans multiple contracts. You can have, like I said before, a partial settlement. There's also the provision for a no-cost settlement, where the parties just kind of look at what's happened, and maybe the contractor's like, yeah, like we were performing at a loss, and we can just walk away from this work. And there might be, specific facts and circumstances that counsel for such a no-cost settlement. And regarding payment, this is, another provision of general principles. And it really, I just mentioned it here. It is a contract-specific kind of term. The contract may authorize partial payments on settlement proposals before settlement. I actually have never seen that before. But if there is some sort of partial payment, there should be no payment for profit or fee. And this is more geared towards the delivery of products. So if the contractor had delivered, 100 boxes of widgets, and then that contract gets terminated, they could probably get paid for that beforehand. And then also I just want to also, just in the general principle section, there is a reference to the FARS cost principles. Now, it should not come as a surprise that the cost principles are informative for terminations, but there's a direct cross-reference to the cost principles under FAR subpart 49.113. And this is for contractors, and I guess the government too, but it's helpful because you can use this to negotiate and determine what costs are relevant to your termination agreement, termination settlement agreement. So if there is any question of what is eligible, some research into case law or other examples where the government has paid out certain costs under the cost principles, that can be very helpful in a situation that, where there might be a question, or maybe the CO doesn't want to pay a certain cost. Next slide, please. Right, and so now we're moving, for the next some minutes, I'm going to address T4Cs in the fixed price context. As I've, just in my own practice, this is the area I've had the most experience in, and I think this is the part where it's the most interesting in a T4C kind of setting. If you have a cost reimbursement contract, the contractor is owed what their costs are, but in a fixed price setting, that kind of context, it's a little bit different, and so the FAR really contemplates explicitly the policy of providing fair compensation. So if you have, for example, a contract where, a contractor is supposed to provide 100,000 widgets, and they make preparations and they perform work, and they are, they're, I guess, building or, producing these widgets, but they don't have them delivered to the government yet. And then the government terminates the contract for convenience. It's not any fault of the contractor. There's just been a policy change or a change in the program. What is fair for the contractor? How do you make the contractor whole? And the contractor should be able to recover its costs after the government changes its mind. And this sometimes, depending on the facts, can be more of an art than a strict accounting exercise to determine what is fair compensation. So the contractor generally should be able to obtain their costs, But the FAR also addresses profit, and it says that profit should be in a reasonable allowance. And basically this profit is applied to the work done and the preparations made. So if you have a factory that was preparing these products or end items to be sold to the government, all that work, profit can apply to that to make the contractor whole. What's excluded from profit, however, is any of the expenses the contractor incurs in negotiating settlement. So that's a classic rule. And then also the FAR prevents a windfall to the contractor. That's the bullet addressing adjustments for loss. Basically, if the contractor had bid low to get the work and then was performing at a loss, they're kind of buying in a situation where they're buying in, or maybe they just made a miscalculation and just had a fixed price contract and they were sometimes it happens in construction where they're supposed to build something and it costs way more than they anticipated. You can't get any profits if you are ultimately performing at a loss. And sometimes there will probably need to be analysis done to justify that. The government might push back on any claim for profit if it's apparent, if the government knows that the contractor is not performing or performing at a loss. And then also in determining the fair compensation owed to a contractor, there will be deductions. For example, if there's a settlement amount reached, if the contractor is able to retain any of the inventory and possibly sell that to someone else or use it elsewhere, there will be deduction for that. Also, if there is inventory that is somehow lost or undeliverable before the title transfers to the government, that will be deducted from the settlement amount. That's contractor's still on the hook for that. And then any other means that are appropriate. And the FAR has this provision that talks about what is appropriate. And so again, this is where it's more of an art than a science or an accounting exercise, where the parties will have to come to an agreement depending on the particular facts and circumstances. And then also just a note on completed end items. If these items are completed but they're not yet delivered, the government should have the obligation to inspect and accept them if this occurs prior to termination for convenience. And so that just kind of wraps up in the effort to make the contractor whole, all these provisions talk about how to come to a fair and accurate accounting so that the parties can release claims from each other. And next slide, please. Right, and so with that goal in mind, the effective way to memorialize that is to put it into a settlement proposal. And here on this slide, I just want to address settlement proposals and components of them, such as disposal schedules, and that there are limits to what can be settled. And then also just a note on equitable adjustments. So basically, a settlement proposal is the opportunity for the contractor to bring their position or their justification to the government and say, hey, these are the costs that we incurred. We signed this contract. We began performance 2 years ago. We, we went to this country, or we, undertook these efforts to perform and incurred all these costs. Those costs may not be apparent to the government. They might have never been documented to the government up until this point. Particularly if it's in a fixed price scheme for products or services either have not been delivered or performed yet. So for the whole wind up and the contractor preparing to perform, the CO might not know the extent to which the contractor has expended resources. So in the TSP, the narrative has to lay out all of the undertakings by the contractor and also provide a tabulation of those costs with justification and documentation. That will, receipts, right? You want to prove that maybe the supplies that were obtained or the labor hours expended are documented and justified. And the settlement proposal is usually due within 1 year. I mean, the FAR, in the contract clauses provide that it can be extended, but you don't want to wait. Memories fade, witnesses disappear, maybe there's evidentiary issues. So the sooner you can get a settlement proposal in, generally, it should be accurate, should be well written, should be fully documented, but it should not be unduly delayed. Also, with in coming to a settlement proposal, depending on the contract, a contractor will have to provide a schedule of all the inventory. This is, I believe, within 60 days, so it's much sooner than the TSP. But the contractor has the obligation to say to the government, "Oh, this is everything that we have, basically in stock for performance of this contract." And the government then, upon receiving the disposal schedule, can provide instruction to the contractor of what to do, whether the government will accept that for delivery or provide it to, instructions to the contractor to dispose of it in some other way. And basically, the limitation on settlement, the general principle is the settlement amount payable must not exceed the contract price. We're in a fixed price context here. The contractor can't get a windfall. Of course, the settlement amount can be adjusted downwards, if there's been payments already made on the contract. But the contractor is nearly not allowed to bring forth all these costs and somehow perform better than if they had performed the entire contract. The FAR does not permit that. And then a note on equitable adjustment after partial terminations. The contractor, if you have a couple CLINs chopped of like a delivery contract, and that might impact your overall price, the contractor can request an equitable adjustment for the continued portion. Once I represented a coal company, and they are able to provide coal to a federal agency at a very good price because of the value. But when certain CLINs were removed from the contract, it drove up their production costs because the volume of total coal was reduced. And it all involved, making reservations on transportation with trains and where the coal was stored. So having these particular CLINs removed by the committees of the government because they were switching over from coal use to, I think, natural gas, it really impacted the contractor's business, not just for the loss of the business, but on the way that they were trying to perform the contract. And so what they had to do was, submit a request to raise the price of the remaining coal. It became more expensive for the government, but the contractor really couldn't perform at the prices it was being forced to perform at with the T4C. And so the FAR contemplates this type of situation, and contractors should be aware of it because it's a way to preserve the viability of their business. And just as with other portions of what's eligible for recovery, costs for getting the equitable adjustment are excluded from a settlement on the terminated portion of the contract. Next slide, please. And this is just the last slide on terminations for convenience in the fixed price realm. I just wanted to call out this citation to White Buffalo Construction versus the United States. This is, there's certain cases out there that if you just Google this will come up. You don't need a Westlaw account for it. And it's an older case, about 18 years old now, from Judge Feudy at the Court of Federal Claims. And it just provides, I think, a very good context for how all these principles knit together, where you have a contractor from Oregon that was building an accessible ramp to a government building, and had all these performance problems. Basically, you don't need to go into gory details. It's all laid out in the opinion. But then the decision of the judge really kind of walks through all the different kind of aspects that can happen in a termination for default that's converted to a termination for convenience. And so there's not really a lot of decisions addressing what's appropriate in termination for convenience. They just don't tend to get litigated. But when the stakes are high enough with a T for D, where the contractor really has to, we'll talk about this a little bit later, to convert it to a T for C, then once that T for C exists there, the court walks through the costs that are eligible and what particularly the contractor was able to recover. For example, the contractor could recover compensation for costs related to the settlement that were not subject to the limitation of the contract price, but they were not entitled to recover pre-termination expenses for renting equipment from these other vendors. And the contractor was also not entitled to recover pre-termination payroll costs attributable to work performed by the contractor's owners. And so I was trying to come up with an example, of a case citation that kind of collects all the legal principles together, and that could be a takeaway, since I don't think the slide decks are distributed. For example, like one quote is, when a fixed price contract is terminated for convenience, it is essentially converted into a cost reimbursement contract, and those kind of legal principles are really exemplified by this decision. Next slide, please. Right, and so having covered fixed price contracts, the next 4 slides, I'm going to touch, just being mindful of time, touch quickly on terminations for convenience and cost reimbursement contracts. Now, this is a little bit different, as the White Buffalo quote says, that, you're converting, in a T for C of a fixed price contract essentially converts that contract into a cost reimbursement contract where the contractor has to justify their costs. Well, in the cost reimbursement realm, the contractor is already getting reimbursed for their costs. That's the whole point of the vehicle. So this conversion doesn't have to happen. Hopefully, the way the contract has been administered, it's fairly clear to the parties, about how the contractor is getting paid for the services and products that they're providing to the government. One moment. I just had to wet my whistle. Excuse me. So, the focus of T for C of a cost reimbursement contract, that really comes down to the clause, and that comes down the rights and obligations that have already been allocated between the government and the contractor. And what also happens is that when the T for C happens, the contractor can no longer use the vouchers to get reimbursed. And actually, can we go to the next slide, please? The procedure for for T for C in a cost reimbursement context is very similar to what we already just talked about within the fixed price context. Is that the contractor has to submit a TSP? They also have to submit a disposal schedule of any inventory, and this TSP will usually get audited, and much like the negotiation in the fixed price context, in a cost reimbursement context, the audit that's normal in a cost reimbursement contract. Either either at the time after the contract's been concluded, there an audit might occur. Here, this is supposed to happen at the TSP stage because the contract is being wound up, and then any kind of adjustment to the indirect costs of the contractor. Next slide, please. And then basically, for partial terminations, I don't want to belabor the point. It's just that there has to be sufficient documentation submitted, and that you submit a settlement proposal, much like a complete termination, and your submission of cost reimbursement vouchers. And next slide, please. I'm going to just move through these, and that basically the fee in a cost, if there's any fee provided in the cost reimbursement contract, that is, the general rule that it's how much have you actually, as a contractor, actually performed on the work? Is this T for C happening when the work is 90% done, and is it measurable to 90%? So is it justifiable to pay 90% of the fee? And so what the CO will do will examine the performance and adjust the fee. And the FAR puts out these 6 factors, such as planning, scheduling, technical studies. Does this involve engineering work? Are there a lot of subcontractors? Is this an administratively difficult contract to perform because maybe there's 20 different subs, or maybe there's no subcontractors, and so supervision of subs isn't really something that is required. And then also what kind of winding down activities or termination activities are applicable. So much like the flexibility provided under the FAR in the fixed price context, here in the cost reimbursement context with fee, the CO does have this flexibility to examine what's going on. This is also unfortunately grounds for dispute. If the CO makes a decision that the contractor feels is unjustified and really wants to hammer them and lower the fee, this might lead to disagreements and maybe a protracted negotiation and convincing of the CO to not adjust it so low. Just looking at time. Could we go to the next slide, please? And so now we get to kind of the last meaty topic, T for Ds, or terminations for default. Now, these, this is the kind of, I don't know, well, the first bullet really, puts the nose on it. It's the contractual death sentence. That's kind of the cliche that's referred to a termination for default. Now T for D, this is basically the government's right, though. This is the government's right for actual or anticipate failure of performance. And in my experience, the government knows the power that that T for D has. I wouldn't say that they won't exercise it. That of course they will, but it's not exercised commonly, and sometimes the CO is mistaken, and you have a issuance of a termination for default because there's a breakdown between the parties. Basically, once I represented a contractor that provided real estate management services to HUD, and basically they did get terminated for default because they, which was unfair, but the government's understanding of it was that the particular software program that the contractor had to provide wasn't working correctly. But the CO's understanding of that, there was reasonable minds could disagree about that. But nonetheless, the CO issued or made a termination for default finding. Also, just like T for Cs, you can have partial T for Ds or complete T for Ds. But the FAR, it does permit this conversion of a T for D into a T for C, and also just reinstatement if there's cure. Unfortunately, if there's a termination for default, this can involve extensive litigation, and the stakes are high. A termination for default, the reason it is a quote unquote death sentence is that it really harms company's reputation. This can all go into past performance, and it can be used, a T for D on a contract today will prevent you from getting a contract in the future. So when this kind of situation arises, there's a high incentive for the contractor to fight against it, especially when there's an unjustified T for D, particularly, for example, in that case with the real estate company performing for HUD. Just another note on T for Ds is that under FAR Part 49, this doesn't apply to FSS contracts, federal supply contracts. If your contract is with GSA, there's a different provision under FAR Part 8. I believe it's 8.4. Next slide, please. And just like the White Buffalo case, I wanted to draw the audience's attention to this INRI Greater New Jersey Movers case. That's a case that just really, it's a very simple case. It's about 10 years, or I guess 12 years old now, and you had a small company providing moving services for the Army, and they were terminated for default. They just couldn't get the work done, and it's a decision because the contractor tried to get the T for D overturned into a T for C, and I think and they failed. And the decision is informative because it walks through all the reasons in the justification by the CO. And again, I'm not going to go into depth in the decision. This can be found online. I just wanted to give a citation if you were curious about how a board or a tribunal would examine the principles of implementing a termination for default. Next slide, please. And here, I just want to talk about draw out the differences between termination for defaults, terminations for default, in the fixed price versus cost reimbursement context, what the effect of a T for D does and the procedure of going about it, and some notes about, I guess, money or damages. Basically, it's kind of a weird provision regarding repurchases, which I'll mention in a moment. And so, the thing to remember about T for Ds in a fixed price context is that basically there's been a failure to deliver or a failure to perform. And so, as compared to the cost reimbursement contracts, there's also been a failure, but the kind of allocating of money is very similar to a termination for convenience, where there's going to be a reimbursement of allowable costs. Again, proposed costs are not allowable, but it just because there's been a T for D does not mean that the allowability principles somehow go away. They persist, and basically the effect of a T for D notice or a T for D determination is that the government is not liable for cost, or the contractor is not liable for the cost of undelivered work. But the contractor must repay advance payments or any progress payments, and the government has to pay the contract price for any completed supplies that have occurred. And then there's basically winding up of the contract. The FAR states that the contractor has to be given notice in writing, no surprise oral T for Ds, and the contractor usually, before the formal determination is made, there has to be a show cause, kind of notice and due process almost, where the contractor has to show cause why why it should not be terminated for default. And this will involve a meeting with the contracting officer. Highly recommend if it's any kind of contract of consequence that the contractor obtain counsel when trying to interact with the CO. This could be behind the scenes kind of guidance, but if it's getting serious enough that the contract will be totally terminated and a determination of default occurring, a breach, you'd want able counsel at your side. And this, because before making the determination, the CO is to consider several facts, all the circumstances, such as the terms of the contract, what was the actual failure by the contractor, any type of availability of supplies or services from other sources, any type of urgency from the agency. And if the contractor can frame the issues in a way that show that there's been a breakdown in communication, a misunderstanding on the part of the government, or that there's been a hiccup outside of the contractor's control, like a particular vendor was not able to deliver a part in time, so that delayed the contractor's performance. But now that they have the part, and they will no longer be delayed. It may suffice to convince the CO to walk back the T4D. And just to know about, repurchase against a contractor's account. In researching and preparing for this presentation today, I didn't even know this existed, and I think it's interesting. And I haven't seen this, and maybe someone in the audience has, but basically that the FAR contemplates that even after termination for default, the government might have to come back to the contractor it just fired and buy products or services from them because they're still required. The government still might have a need. Like the contract might have broken down to a point where there had to be a T4D, but the government also realizes, oh, we can't get this stuff from anyone else. We still need to buy it from you, or it makes most sense to buy it, from you, terminated contractor. I just, it does. The FAR does talk about how the contractor has to usually make this determination before issuing a T4D. Like, okay, we're going to fire you and terminate the contract, but we're going to have to come back to you and buy those widgets, which we can't get from anyone else. But the FAR advises that the CO should try to obtain competition, and it does kind of put contractors on notice that even if they're fired and defaulted, that they have this unique product or service, they can't necessarily seek a windfall. Like if the contractor turns around and wants to charge a higher price to the government, kind of maybe it's justified. You just got fired and you no longer have your government contract. The FAR, however, says that if the government has to pay more for the same products that I just terminated on, the CO can make a demand after that transaction for the excess. So it's like, okay, it's really tilted in favor of the government here. And also, just for T4Ds, there's a small provision that just talks about damages and how there should be an assessment of those. Depending on the contract, and most common occurrence that I'm familiar with is a liquidated damages provision. Like for example, in a construction context, where there might be every day that there's no certificate of occupancy for a new building, you're going to have to pay $5,000 in damages, which can be racked up if the delay is long. Next slide, please. This is the last slide I have for T4Ds. And there's a subsection of FAR Part 49 that addresses the surety work. And at my firm, we actually don't do a lot of construction work. There's a partner, Shiva Hamadinia, who does some construction work, and usually which has surety involved in. Mindful of time, I'll just say that the FAR contemplates the need for if a surety will step in to the terminated contractor, and what happens. The government definitely has the obligation to review the offer by the surety to replace the defaulted construction contractor, but it's not obligated necessarily to accept that work. And then there's basically FAR outlines a process where there might have to be some sort of three-party or tripartite agreement between the contractor, the surety, and the government for the replacement work. This can be called, a surety takeover agreement. And then how does that whole transaction kind of get wrapped up? I just draw attention to it, particularly for construction contractors, and that this is a unique element to them. Can we just move to the next slide, please? Right, and the last two slides here, just quickly, because we're running out of time. There are different clauses that distill and boil down or encapsulate all the principles that we just kind of covered that actually get inserted into the contract. And I'd like to draw the audience's attention to the -2 clause, 52.249-2. That is a very common clause, fixed price in excess of the simple acquisition threshold. These clauses, list all the kind of requirements, notice and what it affects and, what the procedure is for terminations. These are all found in the FAR. The T for D clauses, that kind of groups them together there, the 249-8, 9, and 10 clauses. These are also very common. If you're a government contractor and you've never seen these clauses before, pop open your government contract and either it'll be the whole clause will be inserted in it, or it'll be incorporated by reference, so you can at least know what clause is governing your contract. And basically, last slide, please. Next one. Just wanted to, because it's this is government work. FAR Part 49.6 prescribes the forms and notices and settlement requests for subcontractor settlement proposals. There's forms for all this. The government does not necessarily always use them. It shouldn't come as a surprise if you get something that's on this form here, but you're not necessarily bound to required to use them. But they do. If you look in the FAR, if you come to this section, you can find the lists for these forms. You can Google them, and they're somewhat self-explanatory. At least if kind of to get yourself quickly oriented to the issue that whatever issue you're dealing with the CO. And basically, that is the conclusion. I just wanted to thank everyone for attending. It was a education for me to cover FAR Part 49. And I enjoyed talking about the issues. And if anyone had any questions or follow-up, just feel free to shoot me an email. I'm at avictor@nicholslou.com. Thank you.
Thanks for a great presentation, Andrew, and to our audience members, we thank you again for participating with us. If you have questions about this part, please contact our speaker with the contact information you see in the screen. And if you have any questions about federal contracting or need assistance with any of our services, please contact us directly. Thank you again for joining us. This concludes today's webinar.